Yes, Mr. Salter.
May it please the Court. The respondent's case is that the release of claims in the settlement agreement did not extend to any of the deleted payments or to the August 2013 payment, because we say that release is limited to matters arising out of or connected with the claims and counterclaims made in those proceedings. We say that that is the construction which makes better sense both in the commercial context of the settlement agreement and in the context of the structure and wording of that agreement when taken as a whole. With the Court's indulgence, I'm going to structure my submissions in response to my learned friend Mr. Ho into three sections. First, I'm going to make some broad preliminary comments about the rival arguments put forward by the appellants and the respondents, and to indicate why, in our submission, the appellant's interpretation of these provisions leads to results which the parties plainly did not intend. Secondly, I will invite the Court's attention, with, I regret to say, some unavoidable repetition of what has already fallen from the learned friend, to some aspects of the wider context of the settlement agreement that the respondents submit are particularly significant. And finally, I shall make some submissions about the structure and wording of the settlement agreement.
Thank you.
Lords, my lady, I start with some broad preliminary comments about the rival interpretations of the settlement agreement which the parties are contending. In very general terms, the appellants have put forward three grounds on which they say that the deleted payments fall within the definition of claims in the settlement agreement. First, they say that claims in relation to the deleted payments arise out of or in connection with the main action because they were at some time pleaded in the main action but were thereafter abandoned. Secondly, they say that they arise out of or in connection with the main action because they were relevant to the set-aside application. And thirdly, they say they are relevant because the main action, for these purposes, encompassed all aspects of the wider business relationship between the parties. The learned friend Mr. Ho said, put this in terms of encompassing all the important issues in the main action, irrespective of whether they went to any of the pleaded claims. I'll come back, if I may, to two narrower bases of the appellant's case. But I want to start, if I may, with some comments about this much wider third contention. Its fundamental problem is that the boundaries which are encompassed by such a construction are impossible to draw. It's perhaps understandable in those circumstances that the appellants have not sought to paraphrase the words of the settlement agreement or to say, in other words, what they contend is its correct meaning. What they have done instead is to try and write words into the settlement agreement which are not there. We say it's a fatal weakness in their argument that the reasoning put forward by my learned friend leads to conclusions which plainly cannot be right on the clear wording of the agreement, both generally and specifically in relation to the sentence beginning "for the avoidance of doubt," which excludes from the settlement any existing proceedings between the parties other than the main action itself. As the court has been told, my learned friend accepts in so many words that the settlement agreement was not a general release of all claims whatsoever that existed between the parties. That, for the court's note, is paragraph 21.4 of the appellant's skeleton, in the core bundle, tab 15, and pages 179 to 80. It is, however, implicit in many other places in the appellant's wider argument, both in their skeleton argument and in the oral argument employed by Mr. Hove this morning, that the settlement agreement comprised all claims of any kind arising from the wider business relationship between the parties, particularly the UIMP business. On the appellant's case, that is so because that wider business relationship formed part of the defendant's defence in the main action, and so was an important issue. We say that's wrong. It pays lip service to the fact that the settlement deed did not provide for a general release. But at its heart, this argument involves saying that the release was effectively global because the English litigation involved a consideration of the whole of the parties' wider relationship. So what the appellant's argument comes down to, insofar as it's based on this broad ground, is that a non-global release nevertheless effected a global release. To a limited extent, the appellants have now acknowledged this problem, because yesterday afternoon, and it was only yesterday afternoon that we were informed about it, they have belatedly abandoned two aspects of it. First, they have abandoned the argument which was deployed in paragraphs 23.4 and 35 of their skeleton argument, that at the very least, the settlement deed settled claims by the parties in respect of payments made for the purposes of the UIMP business. And secondly, they have abandoned their claim that the settlement deed released claims in respect of the August 2013 payment. We say that both of these concessions, particularly the second, show that the wider basis of the appellant's argument is untenable. In paragraph 23.4 of the appellant's skeleton, I won't invite the court to turn it up, I'll simply read it into the transcript. They said that, at the very least, the settlement deed settled claims by the parties in respect of payments made for the purposes of the UIMP business. With one exception, all of the deleted payments were in fact made for that purpose. That's an assertion which they then repeated in paragraph 35, which Lord Justice Nugee has now struck through Mr. Ho's agreement. In our submission, their concession that that argument is unmaintainable was clearly correct because it faces two insuperable hurdles. In view of the concession, I can take these points very shortly, but they are, we submit, of more general significance, so I will, if I may, just say a little bit about them. The first hurdle is that despite the valiant effort in paragraph 35.2 of the skeleton to bolster the factual assertion that all but one of the deleted payments was made for the purposes of the UIMP business, that assertion is not common ground, and moreover has no sufficient evidential foundation. Although, as my Lord Justice Nugee has observed, the purpose for which the deleted payments was made was a pleaded issue in the interpretation action from which this appeal is brought. It's paragraph 27.2 of the amended defence and counterclaim, at tab 9, pages 110 to 11 of the core bundle, and paragraph 21 of the reply and defence to counterclaim, which is in the supplementary bundle, tab 17 at page 332. There was simply no evidence tendered at trial before the learned deputy judge to support that assertion, and she made no findings in relation to it. The court can see this. Again, I won't invite the court to turn it up. In the judgment at the core bundle, tab 5, page 39. That contains the section of the deputy judge's judgment which was headed witnesses. And as is clear from paragraphs 8 and 9, the only witnesses who gave evidence before the deputy judge were the solicitors on either side. Two of them are actually in court at the moment. My friend Mr. Jones, Mr. Thomas. I've done this so many times, I'm sorry. My friend Mr. Thomas and my friend Mr. Lyons behind me. They are among the people who actually negotiated the settlement agreement. I'm afraid I made the mistake of mischaracterising Mr. Thomas's name in the course of the main action on a number of occasions, which I apologise.
I assume their evidence was primarily directed at the rectification aspect of the case.
Entirely. Their evidence was confined to the negotiations. Neither Mr. Binobey nor Dr. Al-Hezaimi gave evidence in the settlement action. And the absence of evidence is not surprising. The purpose for which the deleted payments were made, we say, had not been an issue in the main action. Certainly not an issue in the main action in relation to which either party had sought any substantive relief. And consequently, neither side had sought or given disclosure in relation to it. A fortiori, when it came to the Interpretation Act, no disclosure was given in relation to it, and neither party thought to deal with it in their evidence.
When you say the Interpretation Act, you mean the 2020 proceedings from which
I mean the present action from which this appeal is brought.
Yes.
To the extent, therefore...
So when you say the purpose for which the deleted payments had not been an issue in the main action, do you mean ever or just at the end?
It had not been an issue in the main action in relation to which disclosure had been given, my Lord. I need put the matter for the present purposes no further than that. It was not a pleaded matter which went to any of the claims asserted. It was therefore not an issue for disclosure. Neither party sought nor gave disclosure in relation to it.
The purpose for which the deleted payments have been made.
Absolutely.
And that's because by the time disclosure was given, there'd been an amendment to take them out.
Long before, my Lord, yes.
Right, but so you said it had never been an issue in the main action.
My Lord, I'm sorry, I misspoke.
Right, okay.
The deleted payments were plainly an issue in the main action to the point at which they were pleaded in the particulars of claim. But from the October 2017 amendment.
Sorry, you didn't use the word never. That was my interpolation of your sentence. So, yeah, we're at item now, I think.
Yes.
Presumably disclosure was dealt with as one of the directions given by Miss Amanda Tipples.
In this action, yes.
No, not in this action, in the main action.
Well, sorry, in the directions which he gave in the main action. Lord, it's supplementary bundle, tab 9, page 220.
Yes. So this is December 2017. So the proceedings start in July, I think. There's a return date later that term, but it must have been put off a couple of times because September there's an application to discharge. And we've seen the evidence, or some of the evidence on that, and it all comes before Miss Tipples in December. And by that stage, I think it's really agreed the set-aside's not going to be substantively heard, is it?
There was a dispute about it, my Lord. I was going to come to this in a moment, but I can deal with it now. What had happened was that Mr. Justice Barling's original order had provided for the possibility of the freezing order to be discharged on the provision of alternative security.
In the usual way.
In the usual way. We have here real property and the like. The parties agreed alternative security.
So the freezer falls away.
So the freezer effectively fell away.
Yes.
And the discharge application, therefore, was relevant only to costs and the undertaking.
Yes.
And there was then a dispute.
So there's no urgency to have it determined, which is why it's put off to trial, which seems very sensible, if I may say so.
Indeed. We resisted it on the basis we said it was plainly going to fail. But
that's quite difficult, given the conflict of oral evidence on the affidavit, witness statements. But there we are.
We didn't succeed.
Yes. So Miss Tipple sends it off to trial, but she also gives directions for trial, including disclosure. So this is effectively the first CMC.
It is indeed.
Yeah. Okay. So that explains why no disclosure was given in relation to the deleted payments.
Precisely.
You wouldn't normally expect to get disclosure in aid of an application to set aside for non-disclosure.
You might specifically ask for it.
You might ask for it. You wouldn't normally expect it.
No.
Expect it routinely.
Exactly that. Whichever judge it is, case managing the set-aside application might be asked to order disclosure in relation to some aspect of it, but it would not come automatically in the main action.
Thank you.
Well, the bottom line of that is that the court was in no position to make a finding, and the deputy judge in this action did not make any finding as to the purpose which the deleted payments were made. And therefore, an allegation that the settlement agreement would comprise everything that was paid for the purposes of the UIMP proceedings, and therefore the deleted payments related to the UIMP proceedings, was bound to fail for want of any evidential support. There's no finding, there's a dispute in relation to it. So it would not support Milena Frey's application for a declaration in relation to it. But that's actually a more minor point. It's a good reason why the point has been abandoned, but it is a more minor point. The second problem with this aspect of the appellant's case is broader, but we say even more fundamental. It's not confined to their now abandoned assertion that all claims in relation to payments for the purposes of the UIMP business are settled. It extends to the whole of their expansive approach to the scope of the settlement agreement. And its problem is that it effectively expands the scope of the expression all and any claims or causes of action arising out of or in connection with the English proceedings to encompass all claims and causes of action of any kind arising out of the parties' business relationship as a whole. Now, we freely concede that some parties in the position of Mr. bin Obeid and Dr. Al-Hezaimi might have decided to make such an all-embracing settlement and wipe the slate clean between them. But as the appellants accept, that is not what these parties did. And it's no answer to say, as Milena Frey and Mr. Ho does in paragraph 21.4 of his skeleton, that although it wasn't a general release, it was a general release of all claims arising out of or in connection with the main action, the purpose of which was to wipe the slate clean between the parties of the significant, complex and facts-intensive issues which they were in the middle of litigating before the English court. Because that merely begs the question of what was released and what was not. By saying that that includes the whole of the parties' relationship, it effectively turns the settlement agreement into a general release, but without any settled boundaries. And we say that's unsatisfactory because it provides no clear boundaries to the extent of the release. But we also say it is fundamentally inconsistent with the appellant's second concession in relation to the August 2013 payment. Your Lordships, milady, have the nature of the August 2013 payment. It wasn't pleaded either in the particulars of claim or in the amended particulars of claim in the main action. It is therefore not a deleted payment. It is, however, asserted by the respondents that it is a loan which has not been repaid. And claimed by the appellants in paragraph 23 of their defence that it was made for purposes relating to the UIMP business. But whichever of those versions is right, and this court is in no position to form a view one way or the other, it's plain that the August 2013 payment is one which was made in connection with the wider business relationship between the parties. It was either a loan or it was made for the purposes of the UIMP business. If that payment has therefore not been compromised, as the appellants now concede, how can it be said that other payments have been compromised simply because they arise out of the wider business relationship which formed the background to Dr. Al-Hezaimi's defence in the main action? It makes no sense. The only logical distinction is that the August 2013 payment was never pleaded. That may now be one of the appellant's narrow cases, but their wider case cannot, we say, logically stand with this concession. The appellant's wider case is also, we say, fundamentally inconsistent with the last sentence of the definition of claim, which we say plainly recognises that there are claims arising out of the parties' wider business relationship, and which, I mention in passing, Dr. Al-Hezaimi might well say relate to payments arising out of the UIMP business, which were not intended to be, and were not, in fact, compromised by the settlement agreement. I'm going to come back at the very end of my submissions to the significance of that for the avoidance of doubt sentence. But this introduction is broadly why we say that our construction, that the release is limited to matters arising out of or in connection with the claims and counterclaims. In other words, the APOC payments and the consequent ownership of the English properties in substance, makes better sense both in the context of the settlement agreement as a whole and having regard to the words used by the parties in that context. I will deal, as I mentioned, with the two narrower arguments in the context, in the course of what I have to say about the context and the structure and wording of the settlement agreement. Lords, my lady, with that introduction, may I now turn to say a little bit about the context in which the settlement deed came to be made. I have to be careful in doing this because, of course, I was counsel for the claimants in the main action. My learned friend Mr. Ho was not, but of course Mr. Thomas and Mr. Lyons were there as well. So I was trying to confine myself entirely to what is in the papers before the court at the moment, in what I say. The first point that we make is that after service of the amended particulars of claim on 20th October 2017, neither side made any pleaded claims in the main action in relation to the deleted payments. Can I just invite the court quickly to look at the prayer? It's in tab 5 of the supplemental bundle at page 133.
This is the prayer and the amended particulars of claim.
It is indeed the prayer and the amended particulars of claim in the main action. And as the court will see, we claimed a declaration as to the beneficial ownership of the properties and monies referred to above. Can I just interpose there in the identified assets in the settlement agreement? We identify various properties. We also identify various monies. Those monies are a combination of proceeds of sale and rental payments and monies left over. The point is that the identified properties included blocks of flats and things like that, and individual flats have been sold. Proceeds recovered and the like.
So we say money's left over from what?
From the balance of payments received. Because the payments received and the monies actually put into the properties do not exactly correspond.
Oh, I see. So it's just, if you like, the operating bank accounts of the properties.
My lord, indeed.
But we need to be a bit careful. Money's left over from the payments, but I assume, and I think Mr. Ho accepted this, the payments in that formulation mean the payments now pleaded in the amended particulars of claim and do not include any payments which have been deleted.
Absolutely.
Yes.
Yes.
Lord, I'm sorry if I was not clear about that. That's what I intended to say.
Yeah.
Your Lordship is right to pick me up on that.
As I say, I think it's common ground.
Yes. A declaration as to the beneficial ownership of the properties, an order requiring legal title to transferred, damages or equitable compensation, accounts and inquiries, interests, further and other relief. if I can just show the court behind tab 10, the amended defence and counterclaim. And the counterclaim starts at page 195. The appellants made 3 counterclaims, 2 of which were relied upon by way of equitable set-off. We summarise the details of these in paragraph 8 of our skeleton, but for present purpose it's sufficient, probably sufficient to say that none of them relates to any of the deleted payments. The actual prayer is on page 197. The sum of 30 million, which arise out of the UIMP share sale agreement, pleaded in paragraphs 149 and 150. Damages, as aforesaid, are set out in paragraph 155. That's the claim under an alleged Cairo agreement. Mr. Bin Obey had said that he intended to agree Mr. Al-Hezaimi's stake in the UIMP business on trust. Actually, he said it was under a 1 year, which is slightly different, but it doesn't matter for present purposes. That's denied, but if it was made, it was said Mr. Bin Obeid has failed to act as a trustee, failed to exercise his rights, so they're entitled to damages, statutory interest, and then in 156 on page 196, claim for declaratory relief in the properties. Defendants seek declaratory relief as to their interest in the properties to the extent that they are acquired with funds that beneficially belong to them rather than the claimants. That's the declaratory relief that is sought, which is all a long-winded way of saying that none of them related to the deleted payments. Indeed, these claims, this counterclaim, was added by amendment made to the defence on 17th November 2017, which were made in response to the amendment of the particulars of claim on 20th October 2017, which had removed the deleted payments. So these counterclaims are added at the point at which the deleted payments aren't actually in the particulars of claim any longer. And the court may recollect from our skeleton argument the point that we make in reliance upon the case of the Libyan Investment Authority against King, the decision of a court of appeal, the judgment given by my Lord Justice Nugee. I therefore won't take the court to it, to the effect that once something is deleted, it is no longer in the proceedings. And we say, by this time, the deleted payments having been removed from the particulars of the claim no longer formed any part of the respondent's case. May I just pick up one aside at this point? My Lord Justice Snowden drew an analogy with the position in relation to the discontinuance of an action. And I adopt that in the sense that discontinuance does not abandon the claim. It can be re-brought. But I ought, just for clarity, to say that under CPR 38.7, if you discontinue proceedings after a defence has been served, you need the permission of the court to bring a claim arising out of the same or substantially the same facts. Lord, I just mentioned that for completeness. It's not, we submit, relevant to the present action, but I wouldn't want to take advantage of a point that was in my favour without citing to the court an authority which might be thought to undermine it to some extent.
So that's 37.8, did you say?
38.7.
38.7, thank you.
It's page 1, 2, 3, 4 of the 2024 White Book. Doesn't mean the claim is compromised or abandoned. The court can look at issues such as have you paid the costs, etc. And is there some injustice in allowing the claim to continue? say, simply an aside, I thought for completeness I ought to draw it to the court's attention.
Thank you.
Well, that's my first point. That after service of the amended particulars of claim, neither side made any pleaded claims in the main action in relation to the deleted payments. The only declaratory relief claimed by the appellants was in relation to the properties. They didn't claim declaratory relief in relation to the purpose of any payments, either those in the amended particulars of claim or those which had been deleted. My second point relates to how the parties saw the issues at trial. This again is, we say, an important part of the context of the settlement agreement. Can I invite the court's attention to tab 13 of the supplementary bundle? Starting at page 294, there was, as is usual in complex cases, an agreed list of the principal issues. This included on page 295 as issue 10 the purpose which the particulars relied on in the amended particulars of claim were made. Contained no issues whatsoever relating to the withdrawn payments. To the deleted payments.
Hang on. This is for trial of the action.
The main action, my lord.
Yes, this isn't the list of issues that also govern the set-aside application.
No. My lord, I'm coming on to that, if I may, in a moment. That's the list of issues for trial.
Right.
And can I invite the court then to turn on to tab 14 in that supplementary bundle? In the usual way, both parties lodged written opening submissions. The court has already seen some aspects of this, but I'm going to invite the court's attention to certain others. We don't have in the bundles for this hearing the written opening submissions made by our side. We do have the written opening submissions which were lodged by a learned friend, Mr. Robert Anderson, Queen's Counsel, and Mr. Andrew Scott, who were representing the appellants at trial. And they set out their understanding of the issues which Mrs. Justice Falk had to resolve in paragraphs 3 to 13 of their skeleton argument, starting on page 299 rather. May I invite the court just to read those paragraphs? We submit that the significant passage for today's purposes is in paragraph 13 at the top of page 302. The court's principal task at this trial is to determine who is telling the truth about the purpose which the payments in issue, by which he plainly means the amended particulars of payments 15 are in issue were made. That is the central issue in the case. It will turn for the most part on whether the court believes Mr. Bin obeyed or Dr. Al-Hezaimi.
That's not surprising given the pleadings that we've seen, but that's simply addressing the pleaded case. This skeleton addresses the discharge application in other places.
In only one place.
Well, actually, no. Paragraph 21, it makes the point that it's going to address the counterclaim and discharge application at the end, as it were. So the bit that you've read doesn't address that. It's not intended to. And then the bits that we were taken to about the false account of the purposes for which payments were made between 62 and 68 are then relied upon at paragraph 87.
Well, Lord, I was going to take the court to paragraph 87 and say two things about it. First, the discharge application is said to result from the decision on the trial. Either we make out our case in relation to the APOC payments, or we're said to be lying about that, and actually they were made for the UIMP business, which was Dr. Al-Hezaimi's case. If we're found to be lying about that, then it will follow that we were dishonest in relation to the evidence that we put in front of Mr. Justice Barling and the application that we made, because we were, at that time, knew that all payments were made for the UIMP basis, not just the deleted payments, but all that we said in relation to that was untrue, because after all, there were still payments relied on the amended particulars of the claim that had been put before Mr. Justice Barling. And indeed, the entire basis of the case put before Mr. Justice Barling was, as eventually pleaded, that we had made payments for the purpose of the acquisition of English property. And in those circumstances, if that was found against us, it would follow like the night and the day that we had been dishonest, and therefore that the set-aside application would have to be granted. But we say that the purpose of for which the deleted payments were made was not itself in issue, because we accepted by withdrawing them that they were not made for the purposes of the acquisition of English property. One can get hung up on the idea that the set-aside application was all about the deleted payments. The application was made on the same basis as our case as a whole was pleaded, albeit that we got the payments wrong, on the basis that we had given Dr. Al-Hezaimi money to invest in English property. Dr. Al-Hezaimi said, no, you did not. In his amended defence, he said, you've given me money as my remuneration in relation to the UIMP business, and you have given it to me as payment for my shares in the UIMP business. That's the two largest of the APOC payments. The court, it's basically a choice between two accounts. There's no sort of middle ground, although one might deal with individual payments. Either our case is right, these monies were given for investment in English property, and you've been fraudulent, Dr. Al-Hezaimi, or no, you've fraudulently made up a case that you gave it to me for investment in English property. Actually, these were for entirely other matters. The APOC payments, as much as anything else, the whole of your case is based on that. And that's why the learned friend Mr. Anderson rightly said, and I didn't dissent from this, that actually the result of the discharge application will depend essentially on which of the judge believes. If they believe Dr. Al-Hezaimi's case, then we were not merely entitled not merely not entitled to get a freezing injunction from Mr. Justice Barling, but all that we said to him about the investment in English property, irrespective of the particular payments, was untrue. And therefore there was not merely would it automatically follow that we had failed to make full disclosure, we'd actually deliberately misled the court. As I say, it's very easy, because we are concentrating for present purposes only on the deleted payments, to get a wrong approach to the question of the set-aside application in general.
In theory, the judge could have concluded that your case on the APOC payments was well-founded, and granted you relief on that basis, but nevertheless, the deleted payment should never have been included in the claim, and that you had failed to make reasonable inquiries and or deliberately misled the court when applying to Mr. Justice Barling.
My Lord, indeed. There are a whole variety of things the judge could conclude on that. But the first thing is, it was common ground that these payments were not made for the purposes of the investment in English property. Secondly, there was no disclosure given at the moment in the main action in relation to that. So the judge was not, at least at that moment, in any position to make findings as to the true purpose for which the payments was made. If the claimants lost the main action, we say, the court would necessarily have found that they misappropriated. If the defendants lost the main action, the court would necessarily have found they'd misappropriated for their own benefit a very large sum of money belonging in equity to the claimants. That was our case against Dr. Al-Hezaimi. In the circumstances, the application to set aside, would we respectfully submit, have lacked any merit. It would inexorably have followed that the court would have concluded that what Mr. Justice Barling was told about the withdrawn payment was the result of muddle and confusion caused by an almost total absence of record keeping, rather than any deliberate desire to mislead the court. Well, can I return to how the parties saw the issues of the trial by inviting the court to look in tab 15 of the supplemental bundle at what my learned friend Mr. Anderson said in opening the case for the defendants. Again, the court has seen some of this, but not the particular pieces to which I wish to draw attention. Can I invite the court's attention to page 61, where he says, starting at line 11, "Lady, as for common ground, we say there is no dispute that between 2013 and 2016's payments totaling about 35 million were paid by Mr. bin Obeid or on his behalf to Dr. Al-Hezaimi. That's a reference to the APOC payments, which total about £35 million when converted. That is also clear from early in the transcript. He then goes on to say in lines 17 and 18, the issue for my lady is the purpose for which those payments were made, and for whose benefit. About that we are agreed. That's the issue for decision."
I think he means that we're agreed that's the issue.
Well, absolutely.
Yeah.
It doesn't mean we're agreed
No,
about the purpose of law. No. Indeed, that was going to be the subject of some vigorous cross-examination on both sides. But he treats this as a single issue in line 25 in approaching this issue and considering the evidence that Milady will receive in respect of it. Thus, when my learned friend Mr. Anderson started his cross-examination of Mr. bin Obeid on Monday the 17th, everyone knew that the case that was being advanced was about the purpose of the £35 million worth of payment. That was what the parties were fighting about, and all of which is a somewhat long-winded way of showing that the deleted payments and their purpose and or propriety were not seen by either party as issues that were live at the trial of the main action. And our third point, which follows on from the first two, is that after the amendment of the particulars of claim on 20th October 2017, the only relevance of the deleted payments in the main action itself was as to the credit of Mr. Bin Obeid. As I've already said, the court was in no position to make an included determination on that question, other than to find, as was admitted, that they'd not been made for the purpose of investment in English property. And when Mr. Anderson began to cross-examine Mr. Bin Obeid about some of the deleted payments, it was to highlight the fact that Mr. Bin Obeid had put in a witness statement and signed a statement of truth in support of the original particulars of claim, which he now accepted had been wrong. And if I can go back to tab 15 and the transcript again. Page 326, page 65, lines 13 to 17. Ultimately, resolution of that dispute is going to depend upon who my lady believes, Mr. Bin Obeid or Dr. Al-Hezaimi. It is ultimately, to use the vernacular, if I may, a swearing match between the two principal protagonists. The fourth.
I mean, that's essentially the way in which it's put in paragraph 64 in slightly more of the skeleton arguments that you took us to at tab 14, isn't it?
Well, what indeed? Well, indeed. It's tempting to try and, when putting oneself, equipping oneself in aid of construction with all the information which was reasonably available to the parties, to excavate the documents and to look at what was around. But it is, we submit, relevant to that issue of construction, to see what it was that the parties were actually not merely aware of, but were concentrating on at the material time. Because the purpose of the reasonable person being given all the information, or being assumed to have all the information which was available to the parties at the time, it is to put that reasonable person in what is said in another context to be the testator's chair, in the position of the parties when they make their agreement. And we say it's a relevant consideration what they were concentrating on and what they were not. And what they were concentrating on here is the APOC payments. To that, cross-examination in relation to the fact that Mr. Bin Obeid put in a witness statement which he now accepts is wrong, is plainly relevant in the sense that it goes to his credit and therefore undermines his evidence. We don't gainsay that. But it is not, we say, does not make matters simply going to credit in that way. Matters which come within the definition of claim in the withdrawal agreement. I go further than that. I say it would have come as somewhat of a surprise to the parties to have been told that matters simply going to credit were within that. The fourth and also related point of context is that the respondents, my clients, relied upon the fact that the payments related to investment in property in England as founding the jurisdiction of the English courts to try this action. no similar ground would have been available to the respondents in relation to payments made under arrangements made outside the jurisdiction, and payments made outside the jurisdiction for other purposes. The APOC payments were mainly made in Saudi riyals and made outside the jurisdiction. But some of them were made to solicitors or other agents within the jurisdiction. But the deleted payments were all made in Saudi riyals outside the jurisdiction. And given, as was common ground, the deleted payments were not made for the purpose of
I
investment.
thought one of them was 1.2 million euros.
Lord, I'm sorry, am I misleading the court, in which case I apologise.
Payment 5, I think.
Payment 5.
Sorry, a deleted payment 5, I should make.
Yeah, it was made in, I apologise, I should have said were made either in Saudi riyals or in euros.
So I'm not sure where's this going though in terms of context. I mean, for better or for worse, you had got this jurisdiction because you were making claims to properties and monies in England.
We couldn't have added to that unrelated claims in relation to these payments, my lord. We can...
So you couldn't have added to that claims in relation to...
the deleted payments, if we weren't saying they were made for the purposes of English, of investment in English property.
Oh, sorry, because, I mean, the point is you did.
We originally put them in on the basis of an allegation they were for the purpose of English property.
Yes.
Having withdrawn that, we could not have repleaded, as it were, leaving them in and saying, but we want them back as loans or whatever for purposes relating to the UINP business. And so we are giving up on the appellant's case claims to payments that we could not actually have pursued within the jurisdiction. Our final matter of background is that between 27th of May and 25th of December 2018, which is after the October 2017 amendment which deleted the payments, 10 other actions had been commenced in the Kingdom of Saudi Arabia between one or more of the claimants or persons connected with them and one or more of the defendants. I can invite the court's attention in the core bundle to tab 8 at page 87, which is in the amended particulars of claim. The court will see the list. And if the court just keeps its hand in that page and turns briefly on to tab 9 at page 108. You will see that is answered in paragraph 21 of the defence with a non-admission in relation to items 1, 2, 4, 6 and 8, and an admission in relation to numbers 3, 5, 7, 9 and 10. I can invite the court now to turn back to page 87 and to the table there. The court can see that most of these proceedings involve claims for the payment of money, but numbers 6, 7, 8 and 10 relate to UINP or what is described as medical company. For example, item 7, which is one of the admitted items, is described as a claim to amend UIMP KSA shareholders. I also invite the court to note that not all of these proceedings are claims made by my clients against Mr. Ho's clients. Some of them come the other way. And indeed, if I can invite the court's attention back to the judgment of the learned deputy judge, tab 5, page 66, paragraph 64, the learned judge finds, in connection with the negotiations, that Dr. Al-Hezaimi concluded that he was the net claimant in the 2018 Saudi proceedings, i.e. that his claims against the claimant were worth more than the claimant's claims against him. So this is not a case.
Hang on, I'm not sure what that has to do with interpretation.
Well,
that's a rectification.
It is indeed. On the other hand, the fact that they are claims by both sides against each other is the point I'm making in relation to background. Is that this is not a case of Mr. Bin Obeid having a whole series of claims. It's the parties squabbling about other matters in other places. And while I'm rightly corrected by my Lord Justice Snowden for referring to matters which were largely evidence in relation to rectification, I was intending it merely as an illustration without having to crawl through and try to explain to the court who the various claimants and various.
No, I thought you'd done that perfectly adequately by pointing out that numbers 1 to 3 are against the first claimant and number 4 to 10 are by the first claimant. That was all.
Well, Lord, I'm wasting my breath. Then I shall shut up and move on.
I mean, that's the origin, as something you will come on to, the last sentence of the definition of claim.
Well, these absolutely
other proceedings. Yeah.
Absolutely, Lords, yes. And even on the appellant's case, the parties plainly intended to exclude from the scope of the settlements which were the subject of the settlement agreement, the subject of these 2018 Saudi proceedings. Now, these proceedings were on foot by the time the main action came on for trial in June 2019. We can see that from the dates of issue. It is not part of either party's case. The London lawyers involved in negotiating and drafting the settlement agreement had, at the time, any detailed information about the 2018 Saudi proceedings. But it is common ground that by the time of the settlement agreement, both parties knew that some such proceedings exist, hence the reference to them in the definition of claim in the settlement agreement. And although the details of these proceedings were not known to the parties' English lawyers at the material time, it would, we say, be a fair inference that they are likely to have believed these proceedings were, in the nature of things, likely to relate in some way to the parties' wider relationship and the other payments between them, and could even perhaps have involved one or more of the deleted payments. And the existence of these proceedings is, we would submit, a material background fact, because the kind of global settlement for which the appellants now contend would, we say, have required much more careful drafting in relation to these than the for the avoidance of doubt sentence in the definition of claims. Now, with that background in mind, I turn to the last part of my submissions, which is to invite the court to look again at the terms of the settlement agreement in tab 10. I'm going to begin with the structure before I come back to the definition of claim. I know the court has looked carefully at this, so I'll deal with it comparatively quickly, but there are some points to which I wish specifically to draw attention. I start with the recitals under the heading background, which, as my Lord Lord Justice Nugee has pointed out, describe the dispute between the parties as in relation to the beneficial ownership of the real property and money described below as the identified assets. Now they do, as the learned deputy judge went on to say that they wish to fully finally resolve those disputes on the terms of this deed. But again, the matters which they were concentrating on, the matters which they were thinking of, are, we submit, apparent from the recitals. That's the first point in the settlement agreement. That's what we're talking about. And one sees that in paragraph 3.1, the transfer provisions, and in the list of identified assets in Schedule 1. Because what the parties are thinking about there is how to split the identified assets. And the split is to be roughly 80% to my clients and 20% to the appellants. And the mechanics are set out in paragraphs 3.2 and 3.3. The mechanics in paragraph 3 provide for alternative situations. In 3.2, there is a provision that the parties agree that in the 14 days following the date of this deed, they shall use their best endeavours in good faith to reach agreement in relation to the appropriate mechanism for the transfer of the identified assets to reflect the agreed allocation. So, to that extent, it's an agreement to an agree. Then there's a default provision, which is in paragraph 3.3. If the parties don't reach agreement, then a number of things are to happen. And included in those things that are to happen if the parties don't reach agreement is, under letter H on page 132, entering into the discontinuance order and the release order. So in other words, if they reach agreement so that the agreement is complete, the Tomlin order is enough because it stayed on terms of the settlement agreement. But if they don't reach agreement, so the agreement is incomplete, then the default mechanism kicks in. And as part of the default mechanism, there is an order for discontinuance and release. And that, I hope, explains Lord Justice Nugee's point as to why we have separate orders, as it were, or at least provide some explanation of it. Whether it was the best way of drafting it is not a matter the court need be concerned with, but it is that. And one can see, and this is a point relied upon by my learned friend Mr. Ho at page 146, there's a discontinuance order, permission to discontinue, no order as to costs, and under 3, page 147, neither party shall be entitled to be repaid any sum of costs or paid under any order, and no order as to costs. And then on page 148, there's a provision for undertakings, which is set out on page 150. You get replacement undertakings, which the important one is 2. The defendants undertake, it's my learned friend's clients, not to sell or otherwise dispose of or deal with, diminish the value, mortgage, charge, or otherwise encumber, let or sublet any of the 80% of the properties that are allocated to my clients, except with the prior written consent of my clients. And on that basis, the claimants are released from their undertakings, claimant solicitors released from their undertakings, the fortification fund repaid, defendants released from the defendant's undertaking, and security for cost fund repaid to the claimants, and there should be no orders to costs. The point made against me by my learned friend Mr. Hurl is that claims for costs and things like that are not actually claims in issue in the action. Actually, we respectfully submit that they are. If you bring an action, inherent in bringing your action, it is a right to claim your costs subject to the discretion of the court, as it were, but normally costs will follow the event. So it is not a stretch to say that among the claims made in an action are claims for costs, and that also for repayment of sums that have been put across provisionally in relation to that, because that is all inherent in the nature of bringing an action. And it is not, we submit, therefore, a reason why these orders show some wider meaning to the overall meaning of claim in the settlement agreement. We'll come back to the main provisions. Come back to paragraph 4 in a moment. The paragraphs 5 and following are, we say, essentially boilerplate. Warranties and authority, taxations, severance, assignment, no waiver, entire agreement, counterparts, third-party rights, notices, variation, costs and confidentiality. And then over the page, further assistance in good faith and governing law and jurisdiction. None of them is really an operative part of the settlement. Which brings us back to paragraph 4. And as the court has seen in 4.1.1, this deed shall constitute full and final settlement of all claims against each other of the parties and their respective affiliates. And then there's a boilerplate indemnity in relation to that. Which brings us to the definition of claims on page 129. While we're on 129, can I just draw the court's attention to the very wide definition of affiliate at the top of the page, because this claim 4.1 is a settlement of claim against each of the other parties and their respective affiliates. Now, what is settled, as we've seen many times, is all and any claim or cause of action of any kind arising out of, in connection with, 1, the English proceedings, or 2, any claim for rental payments or other proceeds of the identified assets. The learned friend wants the words arising out of or in connection with the issues disputed to be implied into that, or possibly the important issues in dispute in the English proceedings. Those words do not appear. And we see that the definition of claim appears immediately after a recital about settling a dispute in relation to the beneficial ownership of the identified property, and 2, immediately before an express settlement in relation to claims for rental payments or other proceeds of the identified assets, which again shows that the concentration of the parties is on the identified assets and their split and the ownership of those matters.
I wondered whether, in truth, the real difference between you, if you're looking at this clause, is you say that, in essence, little Roman 1 should, or means, arising out of or in connection with the claims in the English proceedings.
Claims and counterclaims.
By which, well, claims in the English proceedings, by which you mean pleaded claims, and including, for the avoidance of doubt, any counterclaims.
Yes.
That's what it says. And that matches the last sentence, you say, because that talks about overlap with the claims in the English proceedings.
Well, Lord, indeed.
Whereas Mr. Ho says, no, that the words to look at in sub little Roman 1 are with the issues in dispute, or any issue, legal or factual, in dispute in the English proceedings.
Lord, indeed.
In essence, that encapsulates the moment where I think the battle lines are between you.
It does indeed.
Speaking entirely for myself.
Lord, your Lordship has, if I may say so respectfully, entirely accurately, that is the battle line between us. And your Lordship, the lady, already has my submissions that the wider construction is so broad and so vague as to be difficult of definition, difficult of certainty. Where does one draw the line in relation to matters which go only to credit? Is it the things that you cross-examined most on? Is it anything that's put us to credit? Is it anything that arises peripherally? After all, the issues in a case are defined by the statements of case. And matters that are raised peripherally, we say, don't sensibly fall within that definition. So we say 1 and 2 show that it is plain that the focus of the definition of claim remains the identified property and the parties' rights in their rights in relation thereto. Now, the following sentence we say is consistent with that, and we say inconsistent with the appellant's wider construction. We make 2 points as to that sentence. First of all, it is not introduced by words like notwithstanding the above, or even so, or as my Lord Justice Nugee suggested, but. What it is introduced with is the words for the avoidance of doubt. Now, those words, given their ordinary and natural meaning, would show that what goes before should properly be construed as not involving a settlement of the 2018 claims. And that is made clear beyond peradventure by the sentence. But it also demonstrates that it should not, that what goes before should not be construed as involving a settlement of those claims. If the purpose of the sentence is truly simply to put the matter beyond doubt, then it helps to explain the proper construction of what goes before, and we say is inconsistent with the very wide construction for which the appellants contend. If it's not to be given its ordinary and natural meaning, this court is effectively rewriting what the parties have said.
See, just picking up that point, if you look at the first time the avoidance of doubt wording is used, it's in the parentheses after the words English proceedings. An order for payment of costs wouldn't ordinarily be regarded as within the sort of species of an issue in the proceedings. I mean, it's an order that's been made. But I can see that, as it were, for the avoidance of doubt, you could say that an order for payment of costs is something akin to it's more akin to a claim rather than an issue.
It's more akin to a claim. Well, Lord, I began by saying it was the claims and counterclaims in the...
Yeah, well, I understand. See, if you insert the words claims in, or you read it as meaning the claims in the English proceedings, you can easily see that for the avoidance of doubt, claims should include counterclaims, because that's
and
a natural reading.
Should include claims for costs too.
Well, I'm actually focusing on those last few words, because they seem to be, if you're right that for the avoidance of doubt should, as it were, just simply restate something which you should be able to find in the prior bit. I'm trying to see how easily I can fit the words orders for payment of costs into the 2 alternative constructions.
Well, my Lord, as I've already submitted to the court, it's inherent in proceedings that you, in this jurisdiction at least, that But if one makes a claim against someone else, one is also claiming one's costs in relation to it. It's common form in old-fashioned, if I can put it this way, chancery proceedings, actually to include a claim for costs in the prayer, but it's not invariable, and it doesn't stop you saying I want my costs, because the court will deal with the question of costs as part of the proceedings. So,
but the language isn't any claims for costs; it's any orders for the payment of costs. It's narrower than that, isn't it?
lady, yes. Well, lady, in one sense, one can say that a claim to the right to enforce an order for costs is a claim in the English proceedings.
Well, I wonder if that's just because since the English proceedings are going to be discontinued, or at any rate stayed, there won't be any more orders for costs. But existing orders, you want to dispose of those as well.
My lord, indeed. And that, of course, one has to read the matter as the settlement agreement as a whole. And of course, those are specifically provided for in the terms of the draft orders, which
Yes.
are scheduled to the settlement agreement. And looking at the matter as a whole, one can see that a line is drawn in relation to costs. But we say it's not difficult to include in claims of causes of action, because what's settled are the claims or causes of action arising out of or in connection with the English proceedings, including claims for costs. Claims arising out of any orders for the payment of costs. Claims made by way of counterclaim. As one starts off with claim or cause of action arising out of or in connection with. So it has to be a claim or cause of action, including avoidance of doubt, counterclaims, and orders for the payment of costs, which then have to arise out of or in connection with the English proceedings. So we submit that there is no inconsistency for the avoidance of doubt. Certainly not sufficient inconsistency. Sorry, Julia was reminding me that the discontinuance order deals with the payments of costs, but I've made that point, I think, to the court. Certainly not any inconsistency which justifies rewriting it, as it were, when it appears again.
So orders for cost is a subset of the wider class that's identified further up the definition. Any claim, ...
Yes,
including without limitation, ... and all for any fees, costs or expenses. So that's just to make clear that what's also being resolved by all of this is any orders that have been made in the litigation.
Really is.
Well, I mean, putting it another way, what's making it clear is you can't seek to enforce any cost order that's been made in the proceedings.
Yes. And it says any claim or cause of action,
I mean,
including without limitation for any fees, costs or expenses arising out of or in connection with the English proceedings, including the avoidance of doubt, counterclaims or orders for payment of costs in those proceedings.
I mean, yeah, I mean, you
it
missed
does
out.
actually hold together.
I'm bound to say, I think you missed out the words which for the parties might have been quite important. I mean, the point is, you can't seek to enforce any cost orders that have been made in the English proceedings against anybody in another jurisdiction after this.
Lord, yes. Lord, the settlement of the claims are, as one goes back to paragraph 4, full and final settlements of all claims against the parties and their affiliates. So you can't seek claims or causes of action, including allegations, defence, counterclaims, set-off, or for fees, costs and expenses in any jurisdiction, under any law, whether civil or criminal, arising out of or in connection with the English proceedings, including for the avoidance of doubt, these things which have happened in the English proceedings, is counterclaims and the making of orders for costs and the like, is actually, we submit, tolerably consistent and clear what that means. And unless one rewrites for the avoidance of doubt when it appears for the second time, one's actually doing violence to the wording that the parties have used. And we say, because of the context, which I have already invited the courts to attention to, there is no justification for doing that kind of violence, the rewriting, or giving the words notwithstanding the above anything other than their ordinary and natural meaning. And we submit that the final words of that sentence, except to the extent that there is an overlap with claims in the English proceedings, provides a clear indication of what the parties intended to settle, i.e. the claims and counterclaims in the English proceedings, and not anything wider. It is showing the kind of things which the parties did not intend to settle. That, we say, shows that things in pari materia are also not within the settlement, irrespective of when the claims be made.
And claims means claims in the narrow sense of a claim, a legal claim asserted in legal proceedings, and not in the wider sense of an assertion.
Absolutely, my lady. In the first time it's used, it's a capitalised expression.
Yeah.
The second time it's used, it's a lowercase expression.
Presumably it would include, for the avoidance of doubt, any counterclaim.
Lord, yes.
Sorry, I'm just reading the words.
Yes.
I mean, we should also, should we, well, sorry, it's a question rather than a statement. Should we, in that last line, read in brackets, including for the avoidance of doubt, any counterclaims?
Lord, I think one, rather than read the words in, claims would therefore mean claims made on, pleaded claims made on either side, which would include counterclaims.
Yes, brackets, including for the avoidance of doubt, any counterclaims.
Lord, yes.
I'm just trying to suggest to you, slightly mischievously, but not entirely. Put it another way, is there any significance that when it uses the words claims in the English proceedings in the last line, we don't get the including for the avoidance of doubt wording? Or was the draftsman just a bit bored with avoiding doubt at that stage?
Given that the drafts people are sitting in court behind me, I shall forbear to...
Well, the hypothetical draftsman.
So, claim includes a counterclaim for the purposes of the rules.
Yeah. I know, which is why it's stated to be for the avoidance of doubt earlier on. And I was simply asking whether there is any, and the answer can very easily be no, there is no point to be taken or significance to be drawn from the fact that those words don't appear further on.
Well, the significance that they don't appear later on is that they are unnecessary.
Yeah, it would be pleonastic.
Because, which is entirely consistent with the fact that the first time they appeared it's for the avoidance of doubt.
Otherwise you get an infinite regress of avoiding doubts.
Precisely. So, in answer to the Lord Justice Snowden, yes, there is significance. The significance is that you don't need it. But the first time it's put in for the avoidance of doubt, and you go on saying for the avoidance of doubt throughout it, and you end up with some very complicated drafting.
Yeah.
And we say, as I say, that the question of overlap shows what the parties here are trying to exclude. They don't want anything that overlaps with the claims, including the counterclaims for the avoidance of doubt in the English proceedings. That's what's being settled.
Yeah.
because only in respect of the causes of action actually asserted on either side is there any overlap, and only in that respect would there otherwise be a settlement. And we also, finally on this point, say that if the avoidance of doubt means anything, it cannot make any difference when proceedings in relation to matters such as those in the 2018 proceedings are commenced. If it's for the avoidance of doubt, truly, then things in pari materia in the 2018 proceedings, that is, things which involve claims which might involve the wider business relationship between the parties, which might involve payments relating to UIP and the rest, are plainly not settled. Because otherwise, this would not be for the avoidance of doubt, it would be notwithstanding, and it would be what the learned friend Mr. Ho described as a carve-out, rather than a clarification, for the avoidance of doubt provision.
In other words, although it says that it shan't prevent the parties from pursuing the litigation currently pending between them, you say it necessarily follows that it doesn't prevent the parties from pursuing new litigation, as long as it doesn't overlap with the claims in the English proceedings.
The Lord, yes, absolutely. Because if it is truly for the avoidance of doubt, then what went before does not preclude that kind of claim, because there is nothing that went before in what went before that has a temporal limitation to it.
It might suggest that the parties recognised there was pending litigation which was going to be continued. They didn't expressly contemplate that the parties were so keen to litigate that they would start fresh proceedings. Otherwise, they might have said you could, but they didn't say so expressly. Or at any rate, maybe one side did contemplate starting fresh proceedings but didn't want to alert the other side to it.
My Lord, of course, it is not permissible to lift the lid on the
No, you can't speculate.
intentions of the parties.
No.
I mean, there was actually a certain amount of evidence about this in relation to the rectification.
Yes, but we quite rightly put all that out of our mind.
Absolutely. And I leave it there. But the point's a short one.
Yeah.
If it is truly for the avoidance of doubt, then what's before can't prohibit that kind of claim, because what went before has no temporal limitation to it.
Yes.
And your Lordship has that point. And we therefore submit that the appellant's wider case impermissibly turns limited release into a general release is inconsistent with their concession in relation to the August 2013 payment and in relation to the exception for the avoidance of doubt in relation to the 2018 proceedings. We say, in the context of the structure and terms of the settlement deed, in particular the expression in the background of what the parties wish to settle, the specific exclusion of rental payments, and the terms of the sentence beginning for the avoidance of doubt, and in the overall context which I have explained of the trial and the settlement negotiation, we say that the construction which makes most sense is one which limits the release of those matters, limits the release to those matters which overlap with the claims, we say counterclaims, in the main action. As I can assist the court further, those are our submissions.
Can you help me with the set-aside application? Well, two things. Firstly, most of your submissions, I apprehend, have really been addressing the third of Mr. Ho's three reasons. Because under his reason 3, he said, these questions, what the disputed payments are for, are all matters which were going to be explored at trial. Therefore, they're issues, important issues at trial. And I entirely understand your answer to that. But the first reason is that deleted payments have a special status because they were originally pleaded and then subsequently abandoned. And there is a point as to whether they were just withdrawn or whether they were abandoned. I wonder if you want to say anything about that.
Well, Lords, perhaps I haven't dealt with at length those 2 points. First point we say is transparently a bad one.
I mean, do you want to say any more than what you said about whatever the Libyan case was, which is once you've withdrawn a claim, it's no longer part of the claim?
Well, Lord, in relation to the first one, I don't want to say any more about that. Your Lordship, I think, has my submissions. It's withdrawn, it's no longer part of the claim.
And that's that?
That's that. And I've shown the court the fact that there were no pleaded claims, no relief sought. I've gone through the context of the matter.
Well, there was one little point on that, which is that when you look at the pleadings in the main action, even after the amendment, the amended defence does plead. This is the purpose of the deleted payments. It's paragraph 25, paragraph 31, and indeed you respond to it in your reply.
Well, Lord,
what is that doing on the pleadings?
Being redundant is the short answer to that, my Lord. Once it's pleaded on the part of the claimants, we at least have to say something
The defendants,
in our reply and defence to counterclaim. And particularly if we wish to assert for any purpose that there is a positive case as to what it is. And it was part of our evidence because it's beyond a peradventure, and in fact happened. Everyone expected this to have been obeyed to be cross-examined about the fact that he had changed his story.
Yes.
Because this was a hard swearing case, whatever else. And there were a very large number of matters which went to credit on all sides. There were an admission at an early stage by Dr. Al-Hezaimi that he had forged a document which he then withdrew. And there were various other peripheral matters like that. So there was a lot of cross-examination material, and that was part of the cross-examination material.
Still doesn't mean it should have been pleaded, but I can see why, from your point of view, once it's been left in the amended defence, because it was there quite properly originally,
yes,
but it was left in even though you withdrew your claim based on the deleted payments. And strictly speaking, you might have been able to get it struck out on the basis that it ceased to be of any relevance. But rather than bother with that, you just replied to it and said it's not true.
Exactly.
Well, that I understand. I think the other point on which I do want help with is the set aside, because the way in which Mr. Ho put it was, whatever the status of the deleted payments in the main action, the set aside discharge application had been adjourned to be heard by the trial judge, so it was part of the proceedings, and that required the trial judge to determine whether the deleted payments had been, let me get this right, whether Mr. bin Obeid's reliance on the deleted payments before Mr. Justice Barling on a without notice application involved a material failure to draw facts to the judge's attention and a lack of full and frank disclosure. And that certainly would involve exploring what the payments were for, what Mr. bin Obeid thought the payments were for, why he said they were for purchasing property, all those issues.
Well, just pause there, my lord, if I may, because I don't accept.
You don't accept that, but that, I mean, I was trying to put to you what Mr. Ho had.
I follow, and can I try and answer it in this way? Two separate points. First, timing. Your Lordship is right that Amanda Tipple's Casey had adjourned the set-aside application to trial, but it was common ground between Mr. Anderson and myself, as Your Lordship have seen, and my lady has seen from paragraph 87 of his skeleton. But actually, it wasn't going to be heard at the trial.
I don't think we'd been told that. We'd seen what Mr. Anderson suggested. I don't think we'd been told that had been agreed, or that Mrs. Justice Falk had accepted that, or what was the position?
It was common ground.
It was common ground. So what was envisaged was you would try the pleaded issues, you'd get a judgment on the pleaded issues, And then you'd
And
come.
then, if relevant, the set-aside application would come on if it was still...
And as you explained earlier, it might well be that if one side was castigated and condemned as not to be believed, then that might determine what happened.
That, my lord, was plainly what Mr. Anderson thought. Your lordship, my lady, do not have my skeleton argument. Materially similar effect, whatever, but it was common ground between counsel that that's what was going to happen.
So it wasn't actually going to be decided as part of the trial.
As part of the trial.
That doesn't matter if it's still part of the proceedings. And in a way, it plainly is still part of the proceedings. It's an application in the proceedings. It's not an application in separate proceedings.
It matters to this extent, because if one's thinking of what the parties meant at the time they were settling the main action, the proceedings that they were dealing with what was there, as it were. And the prospect of the set-aside application was not, how can we put it, on the face of the documents, at the forefront of anybody's mind.
No, but it was plainly being settled as well, in the sense that, as you explained earlier, again, I think this is common ground, all that was left in the set-aside application was an argument over costs and an argument on the cross-undertakings of the damages, and both of those are clearly got rid of by this settlement agreement.
Lord, indeed. Which brings me on to my second point, as it were, which is in relation to what is relevant on the set-aside agreement. Now, the learned friend, Mr. Hill, took the court to the decision of Justice Carr.
Mrs. Justice Carr, is it?
Sorry, Mrs.
Yes.
Justice Carr.
I think
I'm
she then
sorry,
was.
I ought now to say Lady Carr, now our Lord Lady Chief Justice, and invited the court, it's Authorities tab 4, page 80.
She did something which she has a particular knack for doing, which is summarising a very large number of cases in a short set of propositions.
Indeed. The bar and the bench are extremely grateful to her for these convenient summaries. The passage that I wish to rely on is that in subparagraph 10 on page 81, where the non-disclosure is innocent is an important consideration, but not necessarily decisive. Immediate discharge without renewal is likely to be the court's starting point, at least when the failure is substantial or deliberate. Instead, on more than one occasion, it will only be an exceptional cases or in cases of deliberate non-disclosure or misrepresentation that an order will be discharged. But the big thing was not, did we?
You admit you got it wrong. The question was, should you have got it right?
Yes, absolutely. And that does not involve an inquiry for the purposes for which the deleted payments were made. It might involve a question of why we didn't make further inquiries into the deleted payments.
Yes.
Why we made a mistake, why we rushed off to court without actually getting all the documents and having them properly sifted and things like that, and therefore asserted the thing which is not. That's undoubtedly one matter, but that's not an inquiry as to the purpose of the deleted payments. As to the purpose of the deleted payments, they are withdrawn. It is no longer our case that they were made for the purpose for which we put forward in the witness statement and in the skeleton argument.
Can I put it this way? By the time you got to trial, indeed, for quite a long time before then, it was common ground that the deleted payments were not paid for the acquisition of the properties which you were claiming.
Lord, yes.
It was not common ground what they were paid for,
No.
as we can now see, but it simply wasn't an issue.
No.
What they were paid for. What was an issue is, why did you bring a claim based on them falsely?
Yes. And as the passage was from the skeleton of Malone from Mr. Anderson, which I invited the court's attention earlier, show, it was thought that this was a hard swearing match in which there are two inconsistent approaches to the issues in the main action.
Yes.
On our side, we paid you 35 million for investment in English property.
It's our money, it's our property, and you've stolen it.
And you've stolen it. On their side, it was, oh no.
You've paid me 35 million because you owed me 35 million for all sorts of various things, mainly for purchasing my shareholding in UIMP, and the suggestion that this is your money is just nonsense.
Your Lordship has it, precisely. Summarised it better than I can. The one or other of those is going to be believed.
They can't possibly both be true, and they can't be the result of misunderstanding. Somebody is lying.
It's simply as that. So, if Dr. Al-Hezaimi is found to have lied about the payment and the pleaded payments were in fact made and he's stolen it, he was never going to get very far at a set-aside application later because he's an admitted fraudster, as it were. Whereas if we, on the contrary, are found to have lied, to have made up the story about investment in English property.
Yes. I see the way in which you put it. As I said earlier, in strict theory, the judge might have concluded that you were right on the APOC payments, but you should never have based a claim on deleted payments, and you were in breach of your duties to make reasonable inquiries before including them in the action.
My Lord, correct. But that would not involve an inquiry into the purpose for which the deleted payments were actually made.
No.
It would rest upon the admitted fact that we had put forward something which was not correct, and upon an inquiry, something not so far pleaded, not so far gone into, as to what inquiries we made and what investigations we made and why we made the mistake, which is a different issue.
Yes, I see. I now understand the way. I think you did say that before, but it's been very helpful to understand.
Well, I'm sorry if I didn't make it clear the first time.
No, I think it's me being slow. I don't have anything else. No, I think that's all. Thank you very much. Yes, Mr. Hay.
Thank you, my Lord. Just a few short points of reply. First of all, my Lord Justice Snowden asked me at one point where the deleted payments were made to and from. I think my learned friend has cleared that up, and I can just confirm we agree with that. They're Saudi to Saudi. They're all in riyals, apart from one in euros. For the claims that the payments that concerned that were still an issue on the amended particular claims, we say that they were a similar sort of ilk. So again, there were those that were paid Saudi to Saudi. There were some that were paid Saudi to England. And again, I think my learned friend explained that, and I just wanted to confirm we agree with that. The second point is, again, another point raised by my Lord Justice Snowden. He encapsulated the dispute between us on the wording of the settlement agreement in the definition of claims, and highlighted that behind Roman numeral 1, it's a dispute about whether we should, in effect, have the word with the claims in the English proceedings or with the issues that were in dispute in the English proceedings. I just wanted to say one thing about that. We say that it is significant that in the definition of claim, when the parties want to talk about the claims in the English proceedings or specific claims, they use those words. And we see that in the second sentence, and we also see it behind Roman numeral 2, because they say, and I think that should be any claim for rental payments or other proceeds of the identified assets. But we don't see the use of the word claim behind Roman numeral 1. And we say that is significant and deliberate. It's not just confined to the claims in the English proceedings, it's proceedings more generally.
Well, I mean that is the issue. I mean, is it a deliberate omission, or is it, in a sense, an inadvertent omission which can be just read in? But to help us answer that, are you going to come on to deal with the last sentence, the overlap point, if I can put it that way?
Yes, my Lord. Well, as I say, I maintain the submissions that I made about that, noting that it is a carve-out, and that too much emphasis shouldn't be placed on the words for the avoidance of doubt. We say that is just to indicate what the parties had always understood, that these that the litigation that was currently going on between them in Saudi Arabia was not going to be affected by this deed because it's not a general release. And it's only in that narrow case where there is an overlap with the claims in the English proceedings that those Saudi proceedings were to be settled. And that's what the second sentence is achieving.
So their claims means claims, not issues.
No, precisely. It means claims because, and that's important, because you need certainty about what is or is not being released in Saudi Arabia. What you can't have is a dispute, a debate. What the parties wouldn't have wanted is a debate about, oh, well, this particular Saudi dispute involves something to do with the UIP business. Is that connected? Is that dispute connected with the issues in the main action? That could give rise to a host of disputes. It's much simpler, so far as they're concerned, to say, well, is the claim in Saudi Arabia the same as the claim in the English proceedings? If it is, it's released. If it's not, it carries on.
But it's quite curious, isn't it? Because, I mean, read that way, isn't it a substantive, a provision of substance? It's not just for the avoidance of doubt. I mean, it's a substantive provision, that last sentence.
Yes, my lord.
Which is quite odd to find in a definitional section as opposed to in one of the operative sections of the agreement.
Yes, I suppose that might be right, although, I mean, I think everybody has agreed, really, that even the scope of the release is actually, really turns on this definition of claim.
Yes, but in which case, why not put the last sentence into the release, the operative paragraph, section 4, dealing with the release, you know, because that's, in a sense, where it more naturally were to fit.
Yes, I can see. Yes, I can see that, my lord. I mean,
one shouldn't be too critical of the drafting of people who are in court and who drafted under great time pressure.
yes.
And it's fair to say that if it had been drafted in such a way as to give rise to no possible argument, we wouldn't be here. So, by definition, we tend to see the contracts which are where arguments are open. But I see my lord's point, but I also see why you say that it's not actually determined.
It wasn't a point, it was really just a question. I think it's because you, in essence, say don't place too much weight or otherwise on the words for the avoidance of doubt at the beginning of the sentence.
That's right, yes.
And I'm really just sort of gnawing away at that bone, I suppose.
Yes. No, I have to accept your lordship is right, that it might more naturally appear in 4.1, in the release. But it is where it is, and when one looks at the wording that's used, we do say it's significant that what is being talked about is overlap, not arising out of or in connection with, and claims is being used, not just the English proceedings generally.
Okay.
And so that's what we say the function of that sentence is. So that was the second point. The third point to deal with goes to the set-aside application by reason number 2. We do say that the purpose of the deleted payment is relevant to the set-aside application. It's relevant to whether the court was deliberately misled or reasonable care was taken in the presentation of the evidence at the without notice stage. And that's because, depending on what the deleted payment was, it makes it more or less understandable whether Mr. Bin Obeid made the mistake that he did. And we say that's why there was cross-examination about deleted payment number 5, for example, which I've shown the court. That was more than just, well, we know that it's common ground that it's not for the English properties. It was an examination into, well, what is it for? And Mr. Anderson achieved a concession that it was for the bone tissue project. And I don't know how his closing submissions would have gone, but one imagines that he would have said, well, this is all very significant because it's obvious from the documents that if this was the bone tissue bank, Mr. Bin Obeid couldn't possibly have thought it was for anything else. And that's material for our set-aside application. So we do say that it is important to look at the purpose for which the deleted payments were made. That, I think, ties into a point that sort of straddles both reason 2 and reason 3. My learned friend said, well, there was no disclosure in the main action about the deleted payments. So how was anybody to work out what they were for? In my submission, that is a question really that goes to us about how we were going to prove our case. It doesn't change what issues were in dispute. It may be that because we didn't seek disclosure or we didn't make a specific disclosure request in support of our set-aside application, we wouldn't have been able to make good our case. But that doesn't change what the issues in dispute were. And we saw in cross-examination, again, Mr. Bin Obeid being challenged about deleted payment 5. So obviously there was a view that so far as that deleted payment was concerned, we had enough to run our case. And I showed the court the part of Mr. Bin-Obeid's witness statement where he accepted for 4 other deleted payments. They were for the purposes of the UIMP business. Now, Mr. Bin-Obeid wasn't cross-examined about that because
The cross-examination stopped.
the cross-examination stopped, but maybe he would have been cross-examined about that. Again, to make the same point as with deleted payment 5. So we say the lack of disclosure doesn't really assist one with what the issues that were actually in dispute were. Then 2 further points about reason number 3. First of all, we don't say that the logical result of our submissions is that it's a general release by the back door. We say that what is released is the issues in dispute in the main action. Not every aspect of the parties' business relationship was in dispute in the main action. Not every facet of their UIMP relationship was being argued about. What was an issue was the central issue, as we've seen, was what are the purposes of the amended particulars of claim? The payments in the amended particulars of claim. And we said it was important in answering that question to look at the purpose of the deleted payment. That doesn't mean that, therefore, every aspect of the parties' wider business relationship was in dispute so that it becomes a general release by the back door. Finally, for reason 3, to emphasise that the deleted payments were relevant not just to the credit of Mr. Bin-Obeid, but to what the amended particular, what the payments in the amended particulars of claim were. If we could just go back in the supplementary bundle to tab 15, page 324. These are Mr. Anderson's opening submissions. And we've seen that on internal page 61 at line 17 that he identifies that the issue is the purpose for which the payments in the amended particulars were made and to whose benefit. He then says at line 25, in approaching this issue and in considering the evidence which my lady will receive in respect of it, we invite the court to keep 5 general points in mind. And then jumping down to line 10, the second one is secondly and consistently with that point, it's common ground that there was an extensive business relationship between Mr. Bin-Obeid and Dr. Al-Hezaimi, focused on several benches in the Middle East. That business relationship and UIMP in particular accounted for various of the payments which were originally relied upon by the claimants at the without notice stage, which found their way into the original particular claim but have since been abandoned since we put in our defence. That change of position is something we will focus on in the evidence. My submission there is what was being relied on, as far as the deleted payments were concerned, is more than just it's going to the credit of Mr. Bin-Obeid. It's part of this understanding this wider relationship between the parties, and that is important context when working out what the payments in the amended particulars of claim were for. I think the final point, unless I'm corrected, to deal with is just the point in our, sorry to flit around, it's actually a reason 2 point, a set-aside application point, just to deal with our skeleton argument and what was said there. So that is in the supplementary bundle at tab 14. And
You mean your skeleton argument for trial?
Skeleton argument for trial, that's right, my lord. Yes, and it's paragraph 87 on page 326. This is the suggestion that the set-aside application is more, discharge application is more naturally dealt with once the findings that the court makes at trial are known, and so it might be appropriate to address it after judgment. We say it's important to recognise with that the purpose of the deleted payments were some of the things that were going to be investigated at the trial for the reasons that I've already been through, and it's therefore not just the case that, well, stand or fall on the claims that were in the amended particulars claim that would determine the discharge application. There were issues to do with the deleted payments that were going to be explored at trial, that were explored at trial, as we've seen in the cross-examination.
Well, it's paragraph 64 is where I drew Mr. Salter's attention to.
Yes.
That sums it up, doesn't it? Is there anything wrong with what's said in paragraph 64? first two sentences in particular, but a little bit more.
No, my lord, that's exactly it. I mean, I just wanted to emphasise that the changes of case, what happened with the deleted payments were going to be explored at trial. We were going to be inviting findings of fact in relation to that. Yeah. And that obviously would be very material for the set-aside application, and that's why it was being proposed to be dealt with after those findings.
So, I mean, as I understand it, you say it not only goes to, as it were, material non-disclosure and getting an injunction, but it actually shows that, as it says here, Mr. Bin Obeid's evidence is not reliable when you're looking at the purposes for which the payments that were actually in dispute in the case were made.
That's right.
Because he got it wrong in relation to some others as well, quite
That's right,
independently of whether that gave rise to a material non-disclosure argument. That's
right,
how I understand your
Yes,
case.
yes, that's absolutely it. All I was trying to do was meet the submission of my learned friend that, well, globally, the court was going to make a decision between two rival cases. Is it that we were acting as a property agent and we'd been paid this money for that, or is it, no, that was never the agreement and the money had been paid to us because we were entitled to it? And that, answering that question alone would effectively be determinative of the set-aside application. I was trying to meet that point by saying, well, there is more than that. There was more than that in issue at the trial, because the purpose of the deleted payments was going to be an issue at the trial, and that was another reason why we were saying, well, let's deal with the set-aside application after findings on those points have been made. In light of those, that would hopefully make it quite a straightforward thing to resolve.
So even if the set-aside application had never been pursued, you would still be cross-examining on the same basis, because it went to credibility and it went to the reliability of the suggestion that particular payments could be tied to the property investment, which you say was just a fabricated case.
That's right, my lord, and that's the distinction between my reason 2 and my reason 3.
Yes, I understand.
Yeah.
Thank you.
And unless I can assist the court further, those were my submissions in reply.
No, thank you very much, Mr. Mayor. Well, we're very grateful to both counsel and the teams sitting behind them. It won't surprise you to know that we're not going to give a judgment straight away. We will circulate our judgments in draft in the usual way when they are ready. As I'm sure you are aware, they now come with a fierce embargo at the top, which means what it says, and the drafts are your opportunity to correct our spelling and grammar, but not our reasoning. And at that point, we would hope that you would be able to agree a draft order to give effect to our judgments. But if not, short written submissions, and we'll deal with any issues on paper, and the final judgments will be handed down remotely in the way that is now standard. Thank you all very much.